Hello friends, in the series on income tax cases, today we will discuss the case of RN Fashion versus Union of India and others. This case has been reported in 450 ITR at page number 134 and the matter has been decided by Calcutta High Court. The date of the judgment is 20th May 2022. In this case, the notice under section 148A Clause B was issued to the assessee by show causing that why a notice under section 148 should not be issued to you. The last date for the submission of the reply was 18th March 2022. On 18th March 2022 there was a public holiday. On 19th March there was Saturday and on 20th March there was Sunday. The assessee submitted its reply just after those holidays on 21st March 2022. After that, the assessing officer passed the order under section 148A clause D and issued the notice under section 148 without considering the submissions of the assessee which were filed on 21st March 2022. He was of the view that the assessee has not filed its reply on time. So, the notice under section 148 was issued. The assessee moved to the writ court. The assessee's point was that my reply has not been considered in passing the order under section 148A clause D and issuing the notice under section 148. This has not happened only in this case, but in the number of the cases it is happening that whether the reply of the assessee is not being considered or if it is considered, it is only for the namesake. And in some cases it is happening that they are just copy and pasting the complete reply of the assessee into their order and making it the order of 40 or 50 pages. But in the true sense, it is not being considered. Even the deliberation is not done on the points raised by the assessee and it is a plain order of issuing the notice under section 148. So the whole process, I think, which has been laid by the parliament has been made a mockery. So I do not think so that the Supreme Court decision of JKN was incorporated into the statute as it is, that the proper opportunity should be given to the assessee, but that has proved a negatory in the procedure of the income tax proceedings in the case of section 148 notices. But when the assessee moved to the writ court, the writ also was not allowed. So the assessee moved to the appeal against the order of the writ court. But at that time, the division bench of the High Court held that in this particular case, the principle of natural justice has not been followed. The assessee has submitted its reply on time. It was after 3 days holiday. And in this particular case, even if the assessee has filed the reply, after filing the reply, the order was passed. So when the order is being passed, after the filing of the reply of the assessee, then in those cases, according to my knowledge of the law, that reply should be submitted. The department should not be in very haste, and especially when there is time. So in this particular case, the division bench held that the notice under section 148 is not valid and quashed both the notices under section 148 and the order under section 148A clause D. But in this particular case, in the number of the cases, it is happening that the matter is remanded back. So in remanding back the matter, there is a agony on the part of the assessee that the assessee has to follow the whole procedure and the department gets a second chance for rectifying its mistakes. So my point is that whether assessee also gets the second point, because the procedure before the CIT appeal, ITAT and High Court is so long. So according to me, the department should also not be given the time for again playing the game, for again playing the innings. So in this particular type of cases, if the law must have been introduced like that if the High Court quashes the notice, then it should be quashed forever. There should not be any concept of remanding back where the principles of natural justice has not been followed. At the end of this video, once again I am repeating the name of the case. The name of the case is R&T Fashion versus Union of India and others, and the date of the judgment is 20th May 2022. The case has been reported in 450 ITR at page number 134. Thank you, friends.